Data issues. In this module we will define crime, look at how crimes are recorded and some of the problems and limitations of the data thus recorded. We will also look at some of the other forms of data that may help inform the bigger picture, such as the British Crime Survey and the US Uniform Crime Reporting Programme. High quality data is vital for effective law enforcement. Without access to accurate data, the police cannot establish the extent, location and victimization levels of crime and other incidents, and therefore cannot provide an appropriate response. The main problems faced by analysts, and one of which can seriously undermine the analytical process, is oversimplified or poor quality data. The requirement to identify trends and patterns in crime data is an undeniably sound practice. However, good quality data analysis is very much dependent on the quality of the data used. It is unrealistic to think that crime and criminality exist in isolation from other factors impacting upon a community. In understanding crime, it is crucial to take a more holistic view, drawing together patterns and trends in crime and criminality and placing it on a wider social, economic and environmental context, in order to gain a greater understanding of cause and effect. In order to do this, it is necessary to access and examine a range of data beyond simple recorded crime statistics. This may encompass offender and victim details, fear of crime and community safety survey results, socio-economic data, demographic data, data on accident and emergency department admissions, CCTV data, probation records, truancy and school exclusions information, and so on and so forth. Accessing the data can on occasion be problematic, not least of which because there may not be an awareness of the existence of particular data, and despite government policies in encouraging data sharing, there can be a reluctance by organisations or individuals within organisations to actually share the data. Law enforcement agencies need reliable, accurate and timely information with which to manage services, inform users and account for performance. Decision makers make many, often complex decisions about their priorities and the use of resources. Service users and members of the public more widely need accessible and accurate information to make informed decisions. Regulators and government departments need information to satisfy their responsibilities for making judgments about performance and governance. As a consequence, much time and money is spent on the activities and systems involved in collecting and analysing the information used within the law enforcement environment. Good quality information is the essential ingredient for reliable intelligence to support decision making. The information used must be fit for purpose, timely and accurately represent crime and criminality within a jurisdiction. At the same time, there must be a balance between the use and importance of the information and the cost of collecting it to the necessary level of accuracy. Unfortunately, information can be substandard for a variety of reasons, some of which can be dealt with by addressing deficiencies within the collecting agency, others being outside the agency's sphere of influence. However, before beginning to analyse data, it is necessary to appreciate some of the issues which can arise as a result of local reporting procedures, database structure and data quality. The recording practices in respect of crimes and intelligence varies at all levels, not only between countries and jurisdictions, but sometimes within jurisdictions and even between two individual law enforcement officers encountering the same situation. This can be the case despite the existence of crime or incident recording guidelines, which are discussed elsewhere. There are a number of reasons for this. At the base level, police officers have discretion, and as a consequence they, even though a member of the public has reported a crime to them or provided intelligence, may not record it, unless they themselves consider it appropriate to do so. This is particularly true of minor offences or seemingly insignificant intelligence, especially where a police officer is overloaded with work or does not perceive the matter is worth recording. Conversely, certain high-profile crime types or intelligence may be well reported when there is a financial or performance-related incentive or simply kudos associated with the issue. Even before a police officer becomes involved, the accuracy and reliability of information captured in respect of high-volume crime can be questionable, as local crime recording procedures may permit self-reporting via a call centre and finalisation without investigation. A typical example may be theft from motor vehicle, which may be recorded over the telephone by civilian staff working to a script and driven by performance requirements. Similarly, some crimes can lend themselves to being overrepresented. The vast majority of recorded traffic offending is reported either by police officers, civilian enforcement officers, or by automatic road safety cameras. The reason being, there is normally a fine and profitable revenue obtained, whilst very little traffic offending reported by the public will feature in or make its way into official statistics because of the difficulty in following up these reports. Some matters go unrecorded because they are deemed to be insignificant. Conversely, some are arguably over-recorded because they generate reward, and some are inherently flawed because of the manner in which they are collected. It is commonplace these days to find information from various business areas of law enforcement recorded in different electronic databases, although in some jurisdictions a paper or card-based system may be maintained. Business areas may include crime, intelligence, incidents, custody, firearms and so forth, each maintained in a specific database. Structurally, a database may be either flat or relational. A flat file database allows a user to specify the data attributes, such as columns, data types, etc., for one table at a time. A relational database allows a user to specify information about multiple tables and the relationships between those tables. So, for example, in a custody database where it's flat, the details of the individual would appear in the same table as for the reasons of their arrest, whereas in a relational database there would be a table for people's details with a link to a separate table containing details of the reason for their arrest. The latter avoids the requirement to duplicate personal details every time a person is in custody. There are a number of problems with such a system: disparities between flat and relational databases, duplication of records between and within databases, different search facilities, different data formats, a requirement for multiple skill sets to use systems, limited or restricted access, awareness issues, currency and provenance, and so forth. Ideally, information from the different business areas should be held within one all-encompassing database, thereby avoiding these issues and problems. It should be remembered that the actual quality of information within the different business areas can and frequently does vary. They should not be considered to be equally accurate and reliable. In assessing the value of information, consideration should not only be given to the information, but to the source of the information also. In this respect, only intelligence is likely to have some indication as to its value and reliability, having undergone a formal evaluated process. Evaluation of intelligence is discussed elsewhere. Within a database, there are fields for the information required to be captured. So, for example, a person's name and address would appear in different fields. In fact, a person's name will probably be split among several fields, similarly with the address. All databases allow at least 3 field types: alphanumeric, date and number. The correct choice of field type can have a considerable effect on the ability of the database to retrieve information, not forgetting its effect on data quality. Whatever the content of a field is intended to be, it is most important that the correct field type is chosen. Information that isn't retrievable might as well not have been recorded in the first place. It is not uncommon to find that information or data required for analysis is not of the standard required for further processing, or if processed, the results will be flawed and be of little or limited value. Problems with information quality don't always arise from incorrect information. Inconsistent information is a problem as well. Incorrect information is information that is simply wrong. This may be as a result of accidental or deliberate action. For example, in the case of the former, a witness mistakenly reports the colour of a car as black when in fact it was blue, or in the case of the latter, a witness falsely reports property was stolen in a burglary to inflate an insurance claim when it wasn't. Inconsistent information is information that is contradictory. This may be for a number of reasons, including differences in language uses, method of collection and method of recording. An example of inconsistent data will be the use of different words to describe the same thing. For example, shopping centre and shopping precinct. Another example is the amount of data that is collected to describe an entity. In describing an address, there are numerous permutations of house name, house number, street, district, town and postcode. Law enforcement agencies can improve the quality of their intelligence by identifying the information that is important to them and their stakeholders, and securing the quality of the information to support those intelligence needs. This is more likely if the specified information is routinely used for the day-to-day law enforcement agency's activities, and the people who collect the information understand its importance. Information quality refers to the degree of excellence exhibited by the information in relation to the portrayal of the actual phenomena it represents. It can be said to be of high quality if it is fit for its intended uses in crime and intelligence analysis, informing operations, decision-making and planning. Data cleansing or data scrubbing is the action of detecting, correcting or removing corrupt or inaccurate records from a dataset. Used mainly in databases, the term refers to identifying incomplete, incorrect, inaccurate, irrelevant, etc. parts of the data and replacing, modifying or deleting this dirty data. After cleansing, the data will be consistent with other similar datasets in the system. Data cleansing differs from data validation in that validation almost invariably means data is rejected from the system at entry and is performed at entry time rather than at a subsequent time. The actual process of data cleansing may involve removing typographical errors or validating and correcting values against a known list of entities. The validation may be strict, such as rejecting any address that does not have a valid postcode, or fuzzy, such as correcting records that partially match an existing known record. It is not uncommon, particularly in analysis of voluminous crime data or information, for an analyst to spend a considerable amount of their time devoted to cleansing it so that it can be reliably used. Typical corrections that are required include correcting spelling mistakes, correcting abbreviations, correcting unrecognized data to a format that can be recognized, reformatting records where information has been entered into the wrong record field. Data, when subject to drill down or data extraction, may reveal attributes that add additional perspectives to that data. The data thus obtained is known as metadata. It is data about data. In other words, data that explains attributes and features of other data. It may be document data about data elements or attributes, for instance name, size, data type, etc., and data about records or data structures, for example length, fields, columns, etc. In the context of crime data, it may capture the basic characteristics of data or an information resource. So, for example, a time and date of an incident may be further characterized by attributes such as hour of the day of the week of the year, season, and counts of those same attributes, etc. It may also represent the who, what, when, where, why, and how of the data examined. Metadata can be used to identify, authenticate, and contextualize records. It can improve accessibility and usability through time, reveal relationships among records, and facilitate understanding of records. Law enforcement agencies maintain databases in a variety of different business areas, all of which may serve to inform crime and intelligence analysis. The analyst should, as far as practicable, be trained in accessing the information the databases hold, security clearance permitting. Most people working within law enforcement will be familiar with the core business areas, which include crime, incident, intelligence, custody, firearms, and dangerous or prolific offenders. These databases contain a wealth of both current and historical information that can assist in the production of intelligence products. However, they are very often only the tip of an iceberg in the terms of proprietary databases an agency may maintain, an examination of which is beyond the scope of this module as it is covered elsewhere. In addition, departments, and for that matter individuals within an agency, often create ad hoc databases for use within a specific environment. Ad hoc databases have restricted access and control. In this context, such a database is one that is created, owned and used by a specific department or function or individual within an organization to meet a specific need. It is not the bespoke software purchased externally by an agency for a specific job, for example, a crime recording database. There is an implication that specifications have not been divulged that would allow others to duplicate the database. It is common practice, because of shortcomings in available databases or because of financial restrictions, for staff to develop an ad hoc proprietary database to fulfill a particular task or need. Whilst they can be highly successful, there are potential problems and pitfalls, including poor design. Most ad hoc databases are created by end users whose area of expertise is something other than designing databases. As a consequence, such databases often suffer from poor design, making errors hard to find and modifications difficult. Professional software developers are trained to develop software in such a way that it can be easily maintained and updated. Not expandable. Ad hoc databases are generally only used by one or two people. Regardless of how useful they are, without making major changes, it's often difficult, if not impossible, to scale them up to support multiple users. Poor documentation. Ad hoc databases are often only partially documented, if at all. Knowledge about the system is retained in the creator's head and passed by word of mouth. As a consequence, knowledge of the idiosyncrasies of the database can be confined to a very small number of people. This knowledge is then lost completely if the users leave the department or agency. Untested. Ad hoc databases typically undergo nothing much more than a cursory testing, often on-the-job testing, and may have hidden errors that only become apparent after a long period of use. May allow unauthorized access to sensitive information. Ad hoc databases can hold extensive portions of the agency's data and can include confidential information about victims, offenders, or even staff. The access control systems for these systems are often much more slipshod than those for a bespoke agency database and may not even exist at all. Physically locating sensitive data on a desktop or laptop computer is fraught with danger, leaving an agency very exposed if the computer is stolen. Easy to introduce discrepancies. Data in ad hoc databases and spreadsheets can very easily be altered, either intentionally or accidentally. Once changed, it can be difficult to track those changes and determine what the original data looked like. Hardware failure. Ad hoc databases exist on a single computer, are often not regularly backed up, and are therefore in danger of being lost if the computer fails. Despite the inherent shortcomings of ad hoc databases, they can and do serve a useful purpose. They should, however, be used with caution. For the crime analyst, and arguably to a lesser extent for the intelligence analyst, it is useful to understand what and how crimes and other information is recorded. So we will now look at what a crime actually is, what a non-recordable crime is, and what is an incident. A crime is a conduct defined as such by statute or by common law, but crime in this context relates to a specific offence. Crime as a concept is rarely defined by the state. As a consequence, every textbook writer tries to define crime. However, it is difficult to attach an exact definition to something which is so diverse. There are motoring offences ranging from simple parking errors to death by dangerous driving. Offences against a person range from a simple slap to murder. A crime can therefore be viewed as some form of behaviour which violates what society considers to be normal, acceptable behaviour. As a consequence, what constitutes a crime can be fluid and contentious, and may vary from one community to another, or from one state to another, although there are often common threads agreed upon by communities and states, for example, murder, theft and rape. In the UK, there is no definition for what constitutes a crime within the statutes. However, a piece of case law dating back to 1957 gives us some guidance. In a court case of the Board of Trade versus Owen in 1957, the court considered that the correct definition of a crime in the criminal law was the following passage from Halsbury's Law of England. A crime is an unlawful act or default which is an offence against the public and renders the person guilty of the act or default liable to legal punishment. Other definitions include a violation of criminal law, a wrong which the government has determined injurious to the public and prosecutable in a criminal proceeding, and any act, default or conduct prejudicial to the community, the commission of which by law renders the person responsible liable to punishment by a fine, imprisonment or other penalty. Similarly, in the United States, the Model Penal Code of the American Law Institute states as its general purposes: A. To forbid and prevent conduct that unjustifiably and inexcusably inflicts or threatens substantial harm to individual or public interests. B. To subject to public control persons whose conduct indicates that they are disposed to commit crimes. Substantially, the English and American definitions, as indeed the others, say the same thing. However, as cultures change and the political environment shifts, behaviours may be criminalised or decriminalised, which directly affects the statistical crime rates. Crime statistics attempt to provide a statistical measure of the level or amount of crime that is prevalent in societies. However, given that crime, by its very definition, is an illegal activity, every method of measuring it is likely to be flawed. There are many different ways of measuring crime, including surveys or checking hospital or insurance records, to mention but two. However, the term crime statistic usually refers to figures compiled by the police and similar law enforcement agencies. It is well known that many, if not most offences, are not reported to the police, and changes in police procedures can have a big impact on how such reported crimes are categorised. It is for this reason that public surveys are sometimes conducted to estimate the amount of crime not reported to police and to ascertain levels of victimization. Such surveys are usually more reliable in providing reliable trends over time, but they rarely encompass all crime. rarely give local statistics that are useful for local crime prevention or enforcement, often ignore offences against children, and do not count offenders brought before the criminal justice system. Crime statistics are gathered and reported by many countries and are of interest to several international organisations, including Interpol and the United Nations. Law enforcement agencies in some countries, such as the FBI in the United States and the Home Office in England and Wales, publish crime indices, which are compilations of statistics for various types of crime. It can be useful in examining crime issues to understand the wider picture. Both national crime statistics and crime surveys can inform in this regard. In the UK, police-recorded crime statistics cover all notifiable offences recorded by the police. This does not mean all criminal offences, as almost all the minor summary offences are excluded, even though the police may record them for investigative purposes. The term notifiable covers offences that are notified to the Home Office, and they are collectively known as recorded crime. In the United States, a similar function is carried out by the FBI. Police-recorded crime statistics provide a good measure of trends in well-reported crimes, are important indicators of police workload, and can be used for local crime pattern analysis. They do not, however, include crimes that have not been reported to the police or that police have decided not to record. Police-recorded crime statistics, like any administrative data, will be affected by the rules governing the recording of the data, systems in place, and operational decisions on allocation of resources. As a consequence, when recorded crime statistics are being examined, they need to be interpreted in the context of this reality. The crime recording process has three key stages. Reporting a crime. Someone reports to the police that a crime has been committed, or the police observe or discover a crime. In these cases, the police should register a crime-related incident and then decide whether to record it as a crime. In the UK, since April 2002, the police comply with the National Crime Recording Standard in making this decision, although generally the police would record these reports of crime if they amount to a notifiable offence and there is no credible evidence to the contrary. Recording a crime. The police decide to record the report of a crime and now need to determine how many crimes to record and what their offence types are. The UK Home Office issues rules to police forces on the counting and classification of crime. These counting rules for recorded crime are mostly straightforward, as most crimes are counted as one crime per victim, and the offence committed is obvious, for example, a domestic burglary. However, they also cover special situations, where more than one offence has taken place, maybe on several occasions over a period of time, or there is more than one offender or victim. Detecting a crime. Once a crime is recorded and investigated, and evidence is collected to link the crime to a suspect, it can be detected according to criteria in the detections guidance contained in the Home Office counting rules. In many cases, someone is charged or cautioned, or the court has taken the offence into consideration. The detections guidance covers these detection methods, as well as certain others where the police take no further action. Crime has been recorded in England and Wales for over 100 years. However, variation in recording practices had made comparisons between police forces and, indeed, national estimates of the level of crime difficult to measure accurately. The Home Office has for some years sought to improve the consistency of police crime recording and, in an effort to do so, introduced the Home Office counting rules. The rules contain a list of all crime types to be recorded and detailed guidelines of how to record crime. Police recorded crime figures depend on the police being aware that an act that the Home Office considers to be a crime occurred. The Home Office counting rules indicates what constitutes a crime and how crimes are defined and counted. They provide national standard for the recording and counting of notifiable offences recorded by police forces in England and Wales, known as recorded crime. They stipulate what type and how many offences in any particular incident should be recorded by police and notified to the Home Office. The counting rules are applied across 9 categories of recorded crime, which include violence against the person, sexual offences, robbery, burglary, theft and handling stolen goods, fraud and forgery, criminal damage, drugs offences and other offences. Necessarily, there has been changes to recording practices over time. In recent years, there has been 2 key changes in how crime is recorded. The first took place in 1998 with amendments to the counting rules. The second was the introduction of the National Crime Recording Standard in April 2002. The changes to the counting rules concerned the recording of multiple victims and added a number of new offences. These changes had the effect of increasing the number of crimes counted. As a consequence, the number of offences for the years before and after this date are therefore not directly comparable. The National Crime Recording Standard, NCRS, was introduced in 2002-2003, the specific aim of which was to improve further the way in which the police recorded crime. It sought to bring about a victim-centred approach to crime recording and to provide a basis for greater consistency of recording between forces. In the long term, the changes brought about by the National Crime Recording Standard will produce recorded crime data which are increasingly reliable and fair and comparable. The focus of the National Crime Recording Standard has been to harmonise police forces' approaches to crime recording in order to improve confidence in the recorded crime statistics and to enable a more robust comparison of police performance to be undertaken. The implementation of a more victim-oriented approach to crime recording will also provide a better measure of this service demand from the police and aims to promote public confidence in the police service as a whole. The Home Office has set out standards for both crime and incident recording under the National Crime Recording Standards and the National Standard for Incident Recording, NSIR. These standards are underpinned by the Home Office Counting Rules, HOCR, and the National Standard for Incident Recording, Counting Rules. The National Standard for Incident Recording was introduced in 2002. It is a framework used by the police to record non-crime incidents and non-recordable crime in a way that is effective and, above all, consistent. It is separate from the National Crime Recording Standard, which records, as we have seen, only notifiable offences, that is, more serious crime. It includes most minor summary offences or those that may be considered to be incidents of antisocial behaviour. The principal aim of the National Standard for Incident Recording is to ensure that all incidents, whether crime or non-crime, are recorded by the police and in a consistent and accurate manner, so as to allow resulting data to be used at local and national level to meet the management and performance information needs of all stakeholders. It is essential, if consistency of approach is to be maintained, in keeping with the established principles of the National Crime Recording Standard, that clarity exists around what an incident report amounts to. For the purpose of the National Crime Recording Standard, a report is any communication, by whatever means, about a matter that comes to the attention of the police which amounts to a National Incident Category List incident. The British Crime Survey was first carried out in 1982, and further surveys were carried out in 1984, 1988, 1992, 1994, 1996, 1998, 2000 and 2001. Since April 2001, British Crime Survey interviews have been carried out on a continuous basis and detailed results from that point are now reported by financial years. The value of the British Crime Survey is that it can provide a better reflection of the true level of crime than police statistics, since it includes crimes that have not been reported to or recorded by the police. The British Crime Survey estimates that around only half of all crime it measures is captured as police-recorded crimes, largely because people do not bother to report crimes because they think the crime was too trivial or the police couldn't do much about it. The British Crime Survey also provides a better measure of trends over time, since it has adopted a consistent methodology and is unaffected by changes in reporting or recording practices. It is an important source of information about levels of crime and public attitudes to crime, as well as other criminal justice issues. The results play an important role in forming government policy. The British Crime Survey measures the amount of crime in England and Wales only. The first survey covered Scotland as well, but now Scotland and Northern Ireland carry out their own crime surveys. The survey collects information about the victims of crime, the circumstances in which incidents occur, the behaviour of offenders in committing crimes. In this way, the survey provides information to inform crime reduction measures and to gauge their effectiveness. The British Crime Survey is also an important source of information about other topics, such as people's perceptions of antisocial behaviour and attitudes towards the criminal justice system, including the police and the courts. The survey also looks at people's attitudes to crime, such as how much they fear crime and what measures they will take to avoid it. The first British Crime Survey estimated that there were 11 million crimes in England and Wales in 1981. However, there were less than 3 million crimes recorded by the police in that year. This gap was called the dark figure of crime. According to the authors, Hugh and Mayhew, 1983, for those categories for which comparison was possible, the survey indicated a considerably greater number of incidents than did the criminal statistics. Only for one category, theft of motor vehicles, were the figures similar. For example, the survey indicated twice as many burglaries than were recorded by the police. Crime in England and Wales is an amalgamation of police-recorded crime and the British Crime Survey figures, a complementary series that together provide a better picture of crime than could be obtained from either series alone. The police-recorded crime data reports on the financial year, for example, April 2007 to April 2008. Police statistics provide a good measure of trends in well-reported crimes, are an important indicator of police workload, and can be used for local crime pattern analysis. British Crime Survey results are based on interviews conducted in the same financial year. For the crime types it covers, the British Crime Survey can provide a better reflection of the true extent of household and personal crime because it includes crimes that are not reported to the police. The British Crime Survey count also gives a better indication of trends in crime over time because it is unaffected by changes in the levels of reporting to police and in police recording practices. In the United States, there is a similar crime reporting scheme to the UK. It was conceived in 1929 by the International Association of Chiefs of Police. They concluded that there was a need for reliable crime statistics and proposed that uniform national crime statistics be collected from city, county, state, tribal and federal law enforcement agencies throughout the country. Today, data is provided by nearly 17,000 law enforcement agencies across the United States. In 1930, having obtained congressional approval, the FBI was designated as the National Clearinghouse for Statistical Information on Crime, it being their responsibility to collect, publish and archive those statistics. The program is known as the Uniform Crime Reporting Program. The data collected is used in law enforcement administration, operation and management and to indicate fluctuations in the level of crime in America. The Uniform Crime Reporting Program collects data on known offences and persons arrested by law enforcement agencies. It does not, however, record the findings of a court, coroner, jury, or the decision of a prosecutor. The Uniform Crime Reporting Programme limits the reporting of offences to 8 selected crime classifications. They are the crimes most likely to be reported and most likely to occur with sufficient frequency to provide an adequate basis for comparison. These 8 crime types are known as Part 1 offences and include murder and non-negligent manslaughter, forcible rape, robbery, aggravated assault, burglary, larceny theft, motor vehicle theft, and arson. The Uniform Crime Reporting Programme collects arrest data on Part 1 offences and 21 other crimes, such as driving under the influence, that are Part 2 offences. The classifications of crime and scoring guidelines that law enforcement agencies use to report crimes to the Uniform Crime Reporting Programme are detailed in the Uniform Crime Reporting Handbook. In addition, it contains offence and arrest reporting forms and an explanation of how to complete them. The handbook also provides definitions of all uniform crime reporting offences. In response to the US law enforcement's need for more flexible, in-depth data, the Uniform Crime Reporting Programme formulated a national incident-based reporting system as a replacement for the Uniform Crime Reporting Programme's summary system. Under the new reporting system, participating law enforcement authorities provide to the FBI an individual record for each of the 46 specific criminal offences, including the 8 Part 1 crimes which occur in their jurisdiction. Details about each incident include information about multiple victims and offenders. Arrest information on the 46 offences plus 11 less offences is also provided. National Incident-Based Reporting System presents comprehensive, detailed information about crime incidents to law enforcement, researchers, governmental planners, students of crime, and the general public. The US Department of Justice's National Victimization Survey estimates the number of unreported serious crimes nationwide. It is similar to the British Crime Survey. The Uniform Crime Reporting Programme and the National Crime Victimization Survey were designed to complement each other. As we have seen, the Uniform Crime Reporting Programme provides a reliable set of criminal justice statistics as well as an indication of fluctuations in the level of crime. The National Crime Victimization Survey provides information about victims, offenders, and crime, including crime not reported to the police. The two programs employ different methodologies, but they measure a similar subset of serious crimes. Both programs cover rape, robbery, aggravated assault, burglary, theft, and motor vehicle theft. The programs examine crime problems from different perspectives. As a consequence, their results are not strictly comparable. Crime in the United States is an annual publication in which the FBI compiles volume and rate of crime offences for the nation, the states, and individual agencies. This report also includes arrests, clearance, and law enforcement employee data. Crime in Canada. Canada, like the USA and the UK, has undertaken its own Uniform Crime Reporting Survey. Conducted since 1962 by Statistics Canada, it correlates and publishes data on all criminal incidents reported to and substantiated by the various Canadian police services. In addition to using police-reported data, crime is also measured using the self-reported victimization surveys, such as a General Social Survey, which is known as GSS, on victimization. Uniform Crime Recording, UCR Survey. The scope of the Uniform Crime Reporting Survey is criminal code offences and other federal statutes that have been reported to federal, provincial, or municipal police services and have been verified through investigation by those services. Coverage reflects essentially 100% of the total criminal workload of all police services in Canada. The Uniform Crime Reporting Survey describes the trends in the volume and severity of crime reported and recorded by the police at national, provincial, territorial and census metropolitan area levels. Furthermore, it examines in closer detail trends in specific offences such as homicide, sexual assault, break-ins and youth crime. As in the USA and the UK, not all crimes are reported to the police. In Canada, the General Social Survey on Victimization therefore provides an important supplement to officially recorded crime statistics. The main objective of the survey is to garner a better understanding of how Canadians perceive crime, the justice system and their experiences of victimization. It measures both crime incidents that are reported to the police and those that go unreported. It also seeks to understand why some people choose to report a crime to the police whilst others do not. The survey is conducted every 5 years. It is directed at Canadians who are 15 years and older. It asks for respondents' experiences of victimization in respect of 8 crime types, which include sexual assault, robbery, physical assault, theft of personal property, breaking and entering, theft of motor vehicles or their parts, theft of household property, and vandalism. The survey is the only one of self-reported victimization which encompasses all of Canada's provinces and territories. Results are used by police departments, all levels of government, victim and social service agencies, community groups and researchers. Together with the Uniform Crime Reporting Survey, it provides a reasonably complete picture of crime in Canada. We have briefly examined how the levels of crime and victimization are measured in 3 countries. However, most developed and some developing countries have similar mechanisms in place and usually provide relatively easy access to the information and data collected. As we have seen, there are a number of issues that can affect what information and data is collected and how it is stored. Awareness of these issues allows the analyst to make judgment about the quality, limitations and usefulness of the information used in analysis. The message to take away from this lesson is that just because information resides within a law enforcement database, it cannot and should not be considered to be infallible. In addition, it is important that a wide variety of sources are exploited in order to garner a broad understanding of a matter.